welcome. I'd like to welcome you all to this year's Segal Lecture. And let me say, we made it this time. As you may recall, the Segal Lecture was originally scheduled several weeks ago before the hurricane. We had to cancel it with the high winds coming in. Of course, when I heard there was going to be snow coming today, I figured, oh my God, twice. But luckily, it seems to have dissipated, and we're here for something that's truly been a wonderful event here at the University of Pennsylvania over the years. The Segal Lecture, which of course was named after the late Irving R. Segal. Nobody ever called him Irving R. Segal, Buddy Segal, who was truly one of the great trial lawyers, both in the city of Philadelphia and nationally, and a great labor lawyer as well. An incredible litigator, and in his name, the firm, the Segal firm, endowed this lecture to display the great litigators, the great trial lawyers in the United States. And for the lecture, Buddy, when I first became dean, would always sit in the front row, and you would know when the Segal lecturer that year had met the Segal standard. He would sort of, the thumbs would go up and the broad smile. And of course, we've had a list of absolute luminaries over the years who've met the Segal standard. David Boies, Walter Dellinger, Justice Powell, and others, all of which I think gave great luster to this lecture. And I know that Buddy, who has obviously since passed, would be truly tickled pink to be able to hear today's Segal lecture, Stephen Susman, who is truly one of the great trial lawyers of our time, who is going to speak about the joy of lawyering, something, of course, we're all thinking about these days, and the way in which the practice of law is both a wonderful profession and something that serves us personally in the society at large. I could go over sort of the awards Mr. Susman has garnered over the years. They are truly a sight to behold. He's twice been named the leading commercial litigator in the world by the International Who's Who's of Business Lawyers. He's included on the list of attorneys who are the best lawyers in America for over 25 years. And for students in the audience, that is probably longer than you have been alive. He has built an incredibly successful firm, which he's going to talk about, that I think has built a new model of what it means to be a lawyer in this society with various different fee arrangements. He's also litigated some of those high-profile cases on both the defense and plaintiff's side, really shown what it means to be a great lawyer. His accomplishments, I think you could think of in multiple different ways, but I want to really focus on three: the personal, the professional, and then his service to society. First, on a personal level, you have to understand the Susman family has law in its DNA. It's who they are. His mother graduated from law school, widowed, in 1934, and supported he and his brother, who also both became lawyers, as a lawyer herself. You have to think back to 1934, how many women graduated from law school in those years and really became breadwinners for their family as professional lawyers. It says something about what the Susman family was about at that time. The two sons, Steve and Tommy, went on to become great lawyers, and then Tommy's son, Harry, went on and has been in practice of law with him and a partner in the firm. They both share, son and father. They're graduates of the University of Texas Law School, where they were editors of the Law Review. They both were graduates also of Yale, and they both clerked for the Supreme Court. In the case of Harry, it was for Justice Anthony Kennedy, and for Steve, it was for the legendary Justice Hugo Black. He reportedly was the first clerk that Justice Black had, who went on and actually was able to write opinions. The second thing you need to know about Mr. Susman is his entrepreneurial spirit. We talk about what it means to be a lawyer, the intellectual acumen, the ability to articulate arguments in a clear and clean way. He certainly epitomizes all of those qualities, but he's also combined that with an entrepreneurial view about the law and institutions. All goes back to when he was in college, when he was at Yale. He ran three, not one, not two, but three different businesses his senior year. One was a cap and gown rental agency, another a student laundry, and the third a student travel bureau. I guess they combined the two. He continued, obviously, after he graduated in law school, that entrepreneurial spirit as a sort of a creative business person. He's pioneered all sorts of alternative fee arrangements and thought very deeply about how it is you provide legal services and organize them in new and different ways. His law firm is a model in this regard. 90% of its cases come by the referral to them. It's also, I might add, one of the most profitable firms in the United States, with offices in Houston, Dallas, Los Angeles, Seattle, and New York. It is, in some sense, has the entrepreneurial spirit. Every lawyer in the firm is supposed to be thinking about ways of garnering business for the firm. That's not only substantively important, but it's also a way of thinking and an attitude about servicing your clients that is very important these days. He also, I should note, has been involved in winning and settling some of the most important cases. I could go through many of them. He represented Indiana State employees who were awarded more than $42 million for improperly paid salaries. In Samsung v. Texas Instruments, he won a $1.1 billion settlement on behalf of Texas Instruments. And then he's also represented plaintiffs in several successful private antitrust actions against Microsoft, including litigation and private negotiations on behalf of Gateway, Caldera, and others. But the third thing I should mention about today's speaker is that in addition to being very entrepreneurial, an incredible practicing lawyer, he's deeply committed to giving back to the society around him. He's been involved in a whole host of professional activities, the ABA section on Litigation Trial Attorney Advisory Board, as well as the Committee on the Impact of the Crisis on the Profession and Legal Need. He serves on Texas's Supreme Court's Advisory Committee, and it's been very instrumental in their discovery rule revisions. He's taught law school both at his beloved alma mater, the University of Texas, as well as the University of Houston. He's worked on behalf of issues in global warming in Alaska, done pro bono work in stopping development of coal burning plants in Texas. The list really goes on and on in terms of his activities. The latest cause for his firm is on behalf of multiple sclerosis. The entire firm engaged in a 170-mile walk on behalf of multiple sclerosis. So he's truly somebody who understands the importance of being a successful lawyer, but what that means in terms of his commitment to the society more generally. Recently, he was interviewed about being a lawyer whose billable hours were over $1,000 a year. But what an hour, not a year, sorry. And what the interviewer didn't realize, however, was that less than 20% of his work was involved in billable hours. So he's somebody who spends an extraordinarily amount of time committed to social causes and representing other people on a non-fee basis. He really truly epitomizes when we talk about the ideal of the lawyer in the 21st century. I think Buddy Segal would be truly popping buttons right now to be able to see this year's Segal lecturer, Stephen Susman. Welcome.
Thank you very much, Dean. Learned some things about myself I didn't know.
I need to go back and undo what I did and put your soda here.
Leave it over there. It's fine. I'll pick it up. But, you know, where did I put the clicker? Did I put the clicker somewhere?
It's right here.
Here it is. Thank you. Great, thanks. When I selected the topic of my talk for today, I tried to provide as a headline why I am having so much fun being a trial lawyer, and intend to keep it up as long as I have the physical and mental stamina to win. Trying lawsuits is, after all, it's a competitive sport. And while I'm sure I want to quit at the top of my game, I don't know of anything I would love doing more than what I'm doing right now. My first significant gift to my alma mater, the University of Texas Law School, was 2 decades ago when I created a lectureship called The Joy of Lawyering. The notion was to provide a platform for practitioners, academics, and judges to talk about why they loved their work rather than why it presented so many challenges. I was tired of hearing lawyers, and particularly young lawyers, complain about how it was so horrible to be a lawyer in a firm. They didn't like what they were doing, and I thought it was time that we present the people in law schools with some lawyers who were really happy. At the time I set up that lecture, the young lawyers in my firm were obsessed with quality of life and perceiving that they would have to sacrifice family to be successful lawyers, and to work in a firm like mine, which was wrongfully reputed to be a salt mine. It was at a time when many of my friends, my contemporaries, felt trapped in the firms that they were in by the comfortable security that they had achieved, yet they really didn't like going to work every day. It was before it became commonplace for partners to leave established firms for what they perceived to be greener pastures at very similar firms. I felt that law students were too exposed to unhappy lawyers, and I wanted to do something to let them hear from lawyers who were happy and loved practicing law. And my recipe, which I'm going to share with you today, is, as the title of my talk suggests, based on removing stress by securing the right agreements from your law partners, your clients, and opposing counsel. And let me start with what I consider to be the role of agreements in the ideal law firm, of course, my own. Having spent the first 7 years of my practice after I finished my clerkship with which was then one of the largest law firms in the country, even having attained partnership there in record time, I found that in 1974 I was not having fun practicing law. First, I didn't like representing only defendants on an hourly basis. Companies don't usually get sued unless they have done something wrong to someone. The end result of big companies being sued is that after enormously expensive, mind-numbing, and useless discovery, a settlement is recommended by their lawyers for at least nuisance value. Even when you make such a settlement, the plaintiff's lawyer gets bragging rights, and defense counsel comes to be viewed himself as a nuisance by a client who, on second thought, shouldn't have had to hire an expensive lawyer if he didn't do anything wrong. So it was just the nature of the practice at the big firm was not one that I was not enjoying life. Big firms in the mid-'70s were all about billable hours, except you really didn't get compensated based upon how much you produced. Large firms only recently have abandoned lockstep compensation of partners in favor of merit-based pay. I signed a partnership agreement at my first firm, but it provided me with fewer rights than an employee. Yes, we had a manual for firm rules that govern everything we did, but I recognize that it would be years before I had any role in fashioning those rules. As a partner at this law firm, I never voted on anything. I didn't know how partner compensation was established. I never saw a financial statement. I never saw a budget. It was a good job, as good a job as you could get at any large law firm, but that's about it. Actually, in retrospect, it was demoralizing. We always ended up advising the client to settle on the eve of trial, and I was getting too much grunt work, very little courtroom exposure, and no extra compensation for extraordinary hours. So in 1975, I took a leave of absence from the law firm to teach federal courts and antitrust at the University of Texas in Austin. I intended to return to the firm at the end of a semester, but I fell in love with the academic life, and I love living in Austin, reading cases, not having to worry about depositions or interrogatories, writing country music instead of taking depositions. However, when I told my wife that I wanted to go into law teaching, she said, "Not with me, Bubba." She was from Austin, and I was supposed to be, according to her ticket to the big city. I was to take her to the bright lights, wrap her in jewels and fur, and she was not ready to return to Austin as a law professor's wife. So I told her, well, I love you more than I love teaching law, and I don't want to lose a marriage. So I'm willing to go back to the rat race, which I considered it to be, of the law practice. But if I'm going back, if the reason I'm doing this is for money, I'm gonna really try. I'm gonna swing for the outfield. I want to try to get into an area of the law where I can really make some money. And I came up with the idea, well, maybe I'd heard about lawyers in Philadelphia, New York, and Los Angeles, and San Francisco, Chicago, that were making a fortune doing plaintiffs' contingent fee, antitrust and securities work on a class action basis. And I didn't know of anyone in Texas or the Southwest who was doing that. So I spent the summer of '75, a month of the summer, traveling around the country. Actually, I called some lawyers who I'd never met before and asked them whether they would meet with me and talk to me. Two of them were right here, David Berger and Harold Cohn, who were deans of this plaintiffs' antitrust securities law bar. I had not met them before. I called them up. I told them I needed some advice, and they agreed to meet with me. I flew up here, and my question to them was whether there was a market for what they were doing that in the Southwest, an unfilled market, and if so, how should I go about doing it? Well, they were gracious with their time and their advice, and they said, yes, we think there is probably a market. We don't know of anyone who's doing that in Texas or Louisiana or Oklahoma or Arkansas, New Mexico. And but I first asked them, well, can I do this in Austin? Because I wanted to set up a shop in Austin. They said, no, you can't do it in Austin. You have to be in a big city to make this work because there aren't that many cases, and it depends on, you got to get a volume sufficient to make it successful. And then I said, well, can I do it by hanging out my shingle? They said, only if you are very rich, because the nature of this practice, it required a lot of financing of litigation. You have to pay the expenses, you have experts, and it takes a long time when you put water in one end of the pipe for it to come out the other end. So they said, what you really ought to do, Steve, is go try to find a personal injury firm that already does work on a contingent fee basis. It understands the concept of financing cases, and propose to them that you will set up for them, you will get them involved in this commercial litigation. So I went back to Houston, which was my home, and I interviewed with some personal injury firms. They were making this was before tort reform. They were making so much money on store-back cases and bad drug cases that what I was presenting was not very interesting to them. I did find one, a small maritime firm in Houston called Mandel and Wright, which had 5 lawyers when I joined them, and they were willing to try to let me have the freedom to start a commercial litigation practice. I started in January 1976. Before I tell you how it went from there, let me tell you about the first agreement I made, which made all these other agreements possible. That was with my wife, who gave me the ultimatum to either I go back into the practice or I go it alone. She agreed that in exchange for my taking the risk of starting my own practice with nothing in our savings account, she would help me build the new venture. She would help me recruit lawyers, hustle clients, and most of all, take care of the kids so I didn't have to worry about a thing other than going out there and finding sufficient business to support our family. The only requirement was I could work as long as I wanted to, but I had to always take plenty of family vacations. I couldn't give up vacations. And I always took as long of vacations as I possibly could, months at a time. Pursuant to, and I still to this day believe that lawyers should take vacations. And at my law firm, we have a mandatory policy that if you're there for 7 years, you have to take a sabbatical, a paid sabbatical. And you can do whatever you want, but you have to go for at least 6 months. So I then decided to begin developing this practice, and I had a lot of luck when I began. The first thing I wanted to do was to create a firm that was a complete meritocracy when it came to partner compensation. I believe that partners should be paid based on a percentage of what they produced. And the compensation should not be based in any way on seniority. And no one should be paid extra for management or for recruiting or for training or any other function that lawyers in big firms love to spend their time performing. That has been a premise of my law firm for the last 30 years. Second, I wanted a firm that, unlike the one I was leaving, was democratic in its governance and transparent in its finances. But like the one I was leaving, I knew we had to have a written partnership agreement and a firm manual. And I spent a lot of time that first year trying to obtain partnership agreements from other firms, hiring a corporate lawyer from Vincent Elkins in Houston to help us draft a partnership agreement that would serve as a constitution. Over the years, we still have it. It has been amended by a 2/3 vote of the partners a number of occasions to anytime we think we can improve our governance. But there is a written partnership agreement. And also, with a lot of kidding from my other 4 partners at the time, there were only 5 of us, I began drafting a firm manual. They said, why do we need a firm manual? We've never had a firm manual, and there are only 5 of us. I said, because, I don't know why I said it. I did it. I believe that lawyers, it's more fun and easier and less stressful to practice law if everything else is governed by rules that you know what they are and that you had a role in crafting. So at my firm, everyone has a vote. The partners and associates have the same vote. The newest associate has the same vote that I have, or I have the same vote that they have. And we vote on everything. The cases we take, the places we take our firm retreat, the rules. Just last night, I got an email from one of my partners, one of our chapters of our firm manual, which is now multiple volumes, deals with the circumstances under which a lawyer can charge to the firm or a client a cab or a limousine when you go home, back and forth between the office and your home. It never became a problem until we opened a New York office 6 years ago. Now it's suddenly a problem. I didn't know it was really a problem, but I learned last night it was a problem because someone was charging a car Uber. There's something called Uber. I don't know what it is, but it's apparently very cheap. It's like $15. And a $15 charge had been rejected, even though the client, in this case, was paying expenses and expressed a willingness to pay those expenses. So my response is put it on the agenda for the firm meeting on Wednesday, and we will have a firm discussion and vote on whether we should change the rule to allow for lawyers in any office, and the problem is these rules have got to apply to every office equally, whether lawyers should be reimbursed by the firm or the client if you are going between your house and the office and are carrying a briefcase or a box, something you could not carry on a subway. And so that's the kind of thing that, it's a little thing, but it gets under a lawyer's skin. If there's a rule set, you don't know how it got set, you didn't have any say in how it was set, and you send in a voucher and some functionary in the accounting department says, I'm not going to pay that. So that's why we vote on everything. Having put all these agreements in effect, I still needed a lot of luck to succeed. The first good luck came, it was just coincidental, in the form of free publicity at the time I was setting up this operation in the late 70s. At the time, the legal rags, the American Law Journal, the National Law Journal, the American Lawyer, were just getting going. And people like Steve Brill were looking, and reporters were looking for something to write about. And they somehow I got on their radar screen. A lawyer who had been with a big firm was leaving the big firm to go out on his own, which was a very unusual thing to do at the time. And I became a subject that they wanted to write about, and I cooperated. I've learned to deal with the press over the years, and I've learned that you've got to return their calls promptly, real promptly. And I always return their calls. I always have my cell phone. And you've got to tell them something that they can quote. And be as candid as you possibly can with them. And then if you are that way, the press will treat you fine. Well, I was the beneficiary of that kind of press at the beginning of when I set up my firm originally. I was also lucky that I had an undiscovered knack for hustling business. For 7 years at the firm I was with, which was Fulbright Jaworski in Houston, I never asked for business. I learned how to do it real quick when I got out on my own. And I found out not only was I good at it, it was fun. I took a lot of people to dinner. I took them to lunch. I took them to breakfast. I still do. And I still have if anything, the thing that upsets me most about the young lawyers in my firm today is, which includes my son, who's a partner, is that they are so occupied with going to their soccer games, their basketball games of their children. The children are so overbooked, my grandchildren now, are so overbooked with extracurricular activities that the lawyers don't seem to have time to do the kinds of things that I think they should be doing. Every September and October, our judges in Texas are elected. As a result, every night during the week, in September and October, every year, there are receptions for judges. You see a lot of other lawyers. It doesn't cost anything to go, and our firm makes a contribution anyway. So I encourage the lawyers to say, take some of your business cards and go to these receptions and pass out your cards and meet some other lawyers. And when I try to do it whenever I'm in Houston, and I get real mad that I'm the only one there, the young lawyers aren't doing it. Now, maybe they don't have to do it. Maybe there's no fire in their belly, but it's a skill that I'm afraid that I hope we don't lose. From the start, I remember the first year I went to the University of Texas. and the University of Houston it was 1977 to find help. And I was very fortunate to recruit 3 lawyers, each of whom was the editor of their law review. Brilliant. Terry Oxford from the University of Texas, Tex Lazar, who's deceased, from the University of Texas, and Randy Wilson, who's a judge in Houston from the University of Houston. And when we began talking, they just came with me. I think they were just curious about what the firm was going to be like. And because one of the first things we voted on was who were we going to offer jobs, who were we going to look for to hire the next year. And I told them my view was that a trial lawyer needs personality. I mean, Joe Jamel used to brag that he barely made it through law school. And he seemed to do just fine as a trial lawyer. So why couldn't we go hire some Joe Jamel types? And I got voted down on that. They voted, the vote was 3-1 against me. And they said, no, if you only hire the top of the class, quality will attract quality. And so that was the way we began, and that's the way we are today. We have 100 lawyers, 99% of them, or 98% of them, clerked for federal judges. 8 of the lawyers in our firm were clerks for the Supreme Court. So we have a quality bench that's part of the fun of. Now that too makes it fun. I think that if quality attracts quality, and you enjoy being around people who are like you, rather than people. At one time I thought, I ought to go with a firm where I would be the big fish in a small pond. That was wrong-headed. It's much better to be with people who have the same qualifications that you do. Another way I got lucky was, I'm looking here at Alan Black, who's sitting on the front row. Alan and I lucked into a big case called the corrugated box case in 1977. It was a nationwide price-fixing class action that the MDL panel transferred to Houston, Texas. And because there was a fight going on between lawyers from Philadelphia and lawyers from Chicago over who was going to run this case, they compromised by selecting a dark horse, me, to be the lead guy. I was from Houston. No one had heard of me, but it was better than giving the lead position to someone in the other camp. And so Alan was on our steering committee, was one of the Philadelphia representatives who supported my election as chair of the plaintiff's steering committee. And that turned out to be a big case. It got a lot of publicity. It eventually went to trial in 1980. We won a very big verdict. And again, by listening to my wife, who said, my wife asked this question, she said, how have you and your partners at Mandel and Wright decided to split up the corrugated fee? I said, we haven't received the corrugated fee yet, darling. I mean, why should I get in a fight about splitting it up? She said, you won't get in a fight if you split it up now. If you wait till it comes in, you will get in a hell of a fight. So I listened to her again and reached an agreement with my partners at Mandel and Wright about how we split up the fee. And that ended up, I broke off from them in 1980. It was an amicable parting, and I had a large part of the fee that enabled me to set up my own firm. That firm now has 5 offices. We are a little unusual in our structure. We have 60 full equity partners and 40 associates. We are top-heavy with partners. We always have been. And while we do an equal amount of plaintiffs and defense work, most of our income comes from our plaintiffs' work, and most of the fun comes from having the right types of agreements with our client. Those agreements, which the dean mentioned, we are kind of credited with pioneering fee agreements that reward lawyers for results, not effort. On the plaintiff side, it's usually a contingent fee that is heavily negotiated, and that is carefully drafted. We have done it under the watchful eye of Professor Charles Wolfram, the ethics professor, who has for a decade helped us make sure we draft these in a way that we can keep what we thought we had negotiated for. When a new matter comes into our firm, and it's a contingent fee matter, and the conflicts are cleared, the lawyer to whom the matter was brought performs a case evaluation, which results in a brief, not to exceed 5-page memo, which is circulated to all the lawyers in the firm on Monday, talking about what the case is, why it's a good case, what are the worst facts in the case, what are the potential damages, where could we file this lawsuit, and what kind of fee arrangement could we make with the client and with co-counsel or a referring counsel. And then on Wednesday, the firm meets as a whole, all 100 lawyers. We have a firm meeting every Wednesday, and it's most of the time is spent on two things. Most of it's spent on voting on what cases we take. It requires a majority vote. Everyone gets the same vote. A majority vote to take a case on a contingent fee basis where the client is paying expenses. I've had many cases that have been declined, so even I cannot get a case through the system. And if the client wants us to advance expenses, it takes a 2/3 vote. And that's the system, and we have talked about modifying it, but the young lawyers who come to work with us don't want to change it. They are thrilled to be engaged in the intellectual discussion that goes on every Wednesday for an hour is really quite incredible. Well, how about the statute of limitations, and which statute do you use, and can it be told, and what's the effect of this? And it's an in-depth discussion followed by a vote, and the other thing we vote on is all our job offers. No one gets a job offer at our firm unless they receive the majority vote of all the lawyers in the firm. On the defense side, we have developed similar arrangements that reward us for result, not effort. Usually they are fixed fee arrangements, fixed monthly fees that cover part of the value of our time, plus a variety of bonuses dependent on various results, like obtaining dismissal or summary judgment, or settling a case within a short designated period of time, or settling a case for less than a certain sum of money. Very creative arrangements. We encourage the clients to come up with ways that will give us the incentive to treat their case differently than other cases. And at the same time, when at the end of the game, they will not think that they have paid us some windfall because we produced the result that they wanted. And I personally am happiest when I'm working on cases where I only get paid if I win. It means I self-select a docket of cases where I think the client is right and ought to win. And when it makes me happy to get up in the morning and go to work. When you are paid by the hour, you'll take cases that are sure losers, and it is against your interest, self-interest, to insist that the client settle early. When you are paid by the hour, you are always an adversary with your client who will flashback every bill. You have become a slave. You have to become a slave to accurate timekeeping rather than winning work. Finally, the structure of my firm, which is top-heavy with equity partners, our compensation system for partners and associates alike, and the type of work experience we can assign young lawyers, is driven by the nature of our fee agreements with clients. When we are paid for result, not effort, everything we do in a case is preceded by two questions. First, does it really need to be done in order to win? And every time someone suggests, let's take a deposition, they have to make a case for why they want to take the deposition. They have to make a case to the other lawyers in the firm as to what they think they can accomplish by taking the deposition. And I'd say 75% of the time, the senior lawyers reject the idea of deposing the person suggested. So this means that one of the things, the idea that we eliminate a lot of unnecessary tasks, we assign the fewest number of lawyers to perform any task. I mean, I keep telling people, and they all believe it now, one task, one lawyer is what we follow in our firm. And I have suggested to people, and I think it's true, I don't suggest it much in public because the big firms wouldn't appreciate it. But if anyone would come to me with a case that's handled by a big firm for 12 months and tell me what their average billing is, I will handle that case going forward for 50% per month of what they have been billed by the big firm and still make a lot of money. And they want to know, well, how can you do that? And I say, you do it by, the first thing you do, have you ever looked in a deposition that a big firm's participating in? There are 3 lawyers when there should be 1. A mediation, there are 3 lawyers when there should be 1. Have you ever seen the number of people that sit in court that never stand on their feet and say anything? So we kind of at our firm have a rule that if you write it, you get to speak it in court. If you come to court, you get to stand up. And the young lawyers like that. They get a lot of experience, much more than they get at big firms. In the first year, they get more experience taking depositions, arguing motions, actually putting witnesses on at trials than lawyers typically get for the first 10 years at large law firms. Before I leave this subject of representing, the joy of representing plaintiffs, I want to acknowledge that because of the recent election, the contingent fee agreement does appear safe for a few more decades. I was worried that a victory on the right would result in continuing attacks on trial lawyers and litigation under the guise of tort reform, and would start with prohibitions on contingent fees and the enactment of loser pay provisions in a lot of state statutes. We already have one that's being tried out in Texas. I do not think the Democrats will reopen the courthouses to injured parties, but at least they will not shut the doors further. And we clearly have dodged the bullet of 3 more Supreme Court justices that, because of their distrust of juries, have made it even tougher to avoid arbitration, tougher to avoid a dismissal on the pleadings, more difficult to find an expert that can survive a Daubert challenge, and now virtually impossible to get a class certified. All because big companies should not have to face the uncertainty of a jury of their peers. The Supreme Court justices have said that expressly in justifying these door-closing rules. It should be clear that if you have these right agreements with your law partners and your clients, it will influence your philosophy in handling cases. There is a litigation boutique in Dallas that became renowned for its scorched earth, take no prisoner style of litigation. And for a brief period of time, some corporate clients in need of a trial lawyer became infatuated with the idea of hiring the meanest barnyard dog they could find. I'm happy to say that that trend has it's played out. Indeed, it's largely been discredited by federal courts that have adopted civility codes, by the Sedona Institute's recent adoption of a cooperation proclamation. In contrast to my Dallas competitor, our firm promotes trial by agreements. We want our lawyers to be lovers, not street fighters. We tell the young lawyers, you can get more by playing nice with opposing counsel than by playing mean. Courts hate discovery disputes, hate lawyers and can't solve them without court intervention, and usually end up punishing the side that needs a discovery, the plaintiff, by not ruling at all. When the Cargate case ended, I found that defense counsel were recommending me to defend their clients on hourly matters. And before I came to my senses, in the mid-'80s, I was doing more hourly work, almost to the exclusion of contingent fee work. But what I learned from that experience is that the best reference a trial lawyer can have is opposing counsel in his last case. If you gain the respect and admiration of someone you oppose, that is a pretty telling accolade. I also found out that by getting along with opposing counsel and by making and honoring agreements, it means you will have a much less stressful life. You just don't worry about it if two things are said at the same time. If you have a deadline that you need a little more time on because someone in your family got sick or you were asked to do something or whatever it is, because you get in the habit of, with the lawyers you're practicing, cutting each other slack. And it also, working out these agreements, produces a better result for your client. Time and money is not wasted on fights that are not outcome determinative. You can better keep your eyes on what matters if you are not getting mad from bickering with opposing counsel. I tell the lawyers in our firm that just watch the lawyer that gets mad. He is losing, when a trial lawyer loses their cool because they've gotten mad at someone, they lose their effectiveness because they just cannot see the forest for the trees. I also found out in the mid-'90s, serving on the Texas Supreme Court Advisory Rules Committee, I was the chair of their discovery committee, I found out that rulemaking by courts didn't give us very much in the way of promoting cooperative litigation. Oh yeah, I mean, there's a meet and confer requirement that you must comply with before you file motions. But frankly, I've never found that to be very helpful. The rules that are designed by judges in these rules committees are default rules that are designed to be used when the lawyers cannot reach agreement. They're designed to fit all sizes of cases and all types of cases. And worst of all types of lawyers, including inexperienced ones who are afraid of their shadows and disagreeable ones who are afraid to ever say yes. Court-adopted rules are difficult to change, even when everyone agrees that certain aspects of the litigation practice have become intolerable. In the mid-'90s, it was deposition taking. Most of the expense of pretrial discovery was on depositions, not document discovery, because depositions required a lot of preparation time, required a court reporter and eventually a videographer too. And it was just a very time-consuming thing. And we found that 98% of what we learned in depositions, 98% of what was testified to in depositions, never saw the light of day in a courtroom. It was wasted, still is. That's changed. Now the problem of this century is e-discovery. That's the big problem now. The deposition, we have controlled it by time limits, by limiting what lawyers can say in depositions in the way of interfering with the witness's testimony. But we have this e-discovery that is driving everyone crazy and causing a mammoth expense in litigation. So I started developing, in response to all this, a list of agreements that I try to reach with opposing counsel in every case I participate in. Originally, I only had pretrial agreements, but over time, I developed trial agreements, and now they're just called agreements. I have a website today called trialbyagreement.com, where these agreements are posted, updated, changed, and debated. you can go on and sign up and participate in the discussion. It's free. The point is to get lawyers thinking about these agreements, to get them suggesting new agreements, and the guidelines that I suggest to people is that first, you need to provide these agreements to the other side as soon as you know who's going to represent the other side, before battles begin. Because in the heat of war, you cannot make a truce. I mean, the time to get these rules of the game established are before the battle begins. Second, you need to discuss these agreements in person with the most experienced lawyer on the other side. The best partner for peace is one who has had firsthand experience with war. True with litigation too. If you're going to hope to get agreements, you need to talk to an experienced lawyer who knows that by agreeing to something doesn't mean you're giving up something. Who knows, and this is a hard lesson to get across to lawyers, young lawyers, that just because something is good for the other side doesn't mean it's bad for us, and vice versa. It could be good for both sides. And so when people begin thinking about the world in that way, and approaching it in that way, you can really make the handling of cases a lot of fun and less stressful. And third on these agreements is, you get whatever you can get. If people don't want to agree to everything, you don't have to agree to everything. And I'm going to just run through, I'm not going to run through all these agreements because you can get them off the website, but I have a PowerPoint that illustrates what we're talking about, some of what they are. The first one is, it's so aggravating when lawyers, email is so easy today. When lawyers send letters, it's almost always because they want to attach something to a motion for sanctions that they're going to file with the court. And when lawyers send you, and it's also horrible when lawyers write letters which they attach as PDFs to emails. So you've got to get an agreement on something as basic as, we're not going to write letters and we're not even going to attach letters as PDFs to emails. That you just, and you'll send the email to everyone who the other side wants the email to go to. You agree on how long the trial will last and that the time will be divided equally before discovery begins. If the trial is going to last 4 days, with each side getting 2 days, as this demonstrates, it is, you figure out the amount of time that each side gets. If you 4 days of trial, it makes it stupid to take 20 days of depositions. You can only, the judges are now throughout the country talking about proportionality. Proportionality only makes sense if the judges are willing to tell you, here's how long the trial is going to be. Because otherwise, in proportional to what? You get an agreement with the other side on how depositions are taken and how long they are going to last. And I think a deposition should last no more than 3 hours. Well, that's 4 hours less than the federal rules allow. But I think if the other side keeps quiet, and I try to make them keep quiet in a deposition, you can accomplish all you need in 3 hours. That's why I suggest this rule. At depositions, all objections to relevance, lack of foundation, non-responsiveness, speculation, or the form of the question will be reserved until trial. So there will be no reason for the defending lawyer to say anything other than advise the client to assert the privilege or to adjourn the deposition because the questioner is improperly harassing the witness. If counsel violate this agreement, the other side can play counsel's comments and objections in the videotaped deposition to the jury. No one wants that to happen. So you can see that this is the kind of rule that good lawyers, experienced lawyers ought to say, this makes a lot of sense. A 3-hour deposition, but you're not going to mess with my time by making stupid speaking objections. This is mechanics. You can agree on the mechanics of using the same court reporter. service by email is virtually required now. Some of these agreements in this set, documents produced on a rolling basis. Here's one on e-discovery. It's fairly detailed, and I don't expect to cover it now, but there are a lot of local rules that are doing things like this. And all these agreements now, which have become known nationwide as the Susman agreements, are getting known to magistrate judges and courts, particularly on the federal side. And when counsel come in for the first pretrial conference, they're saying, have you considered the Susman agreements? They're handing them a copy and saying, go in the next room and think about these and come back and tell me what you can agree on. Fights about protective orders, the way exhibits are numbered. And I'm not going to go through any more because I suggest that if you're interested in the subject, you can get them. Some of the agreements that I have come up with are pretty new. Like I've now come to the conclusion that there should be no expert depositions at all. The parties should agree that you shouldn't depose experts. Total waste of time in cases. Experts are paid witnesses. The only function of taking an expert's deposition is to alert the expert of mistakes he made, and then he fixes them by the time of trial, and all the surprise is gone. So what have you done? Nothing. So just agree that we're not going to cover. One of my pretrial agreements that resulted in a change to the federal rule was that neither side could ask to see for the other side's communications, the lawyer's communications with the expert. That previously, you could ask for that, or prior drafts of the expert report. And as a result, we all knew this was going on. I would have to send lawyers to Washington, where an expert was located, to stand behind them at a computer or word processor and essentially dictate to them their report. But because you couldn't send anything by email or mail, it would be discoverable. So again, there's one that if both sides know that this is going on, which we do, sure, there are a lot of drafts. They get changed. They get changed because the lawyers are rewriting them. So what? Now the federal rule says you cannot discover an expert's prior drafts or communications between counsel and the expert. That's in the federal rule. And there are other things like this. And this goes on to, there are 13 pretrial agreements. Actually, there are more. I have to tell you this one because this one works, and this has turned out to be great, and a lot of lawyers, some lawyers will not agree to any of these ever, but some will agree to most of them, and this is one that most lawyers have really liked. People, if you handle a lot of cases, you understand that documents, the best documents get hidden on privilege lists. Everyone logs privileged documents, and that's where the good stuff is. Someone has called it privileged. So you look at these privilege logs and you say, that can't possibly be privileged. It doesn't even have a lawyer's name on it. It's happening, it's dated right at the time when things were going on that are important. How can they hold that back on the ground it's privileged? So what this says is that we each get to review the other's privilege list and get to pick at random 20 documents, or 15, it doesn't matter the number, it's the principle. It's the same number of documents you get to pick for no reason whatsoever. But it's a small enough number that you agree that you will submit them to the judge for review in camera. That causes everyone to be honest, because if you submit 20 documents off the other's list to the judge, these so-called privileged documents, the judge knows what's going on. And of the 20, 10 are not, the judge says 10 aren't privileged. You are in a deep load of doo-doo with that judge, and you are probably going to have to hire some special master to review all your documents. But again, if you just have this agreement at the beginning, you can see how it keeps people honest in what they claim is privileged. And then there's a whole series here of trial agreements. They're still called trial agreements, and I'm not going to go over those but they are very similar. I hope that my comments will encourage you who are students here to excel in your studies and consider the happiness you can find as a trial lawyer. Regardless of which party runs the federal and state governments, disputes are not going away. The trial may be replaced by arbitration as a preferred method of dispute resolution, but the skills required to persuade a jury are the same ones that are needed to persuade arbitrators. And every agreement I have proposed can be used equally effectively, preparing for and conducting arbitrations. I think it is generally assumed that the world's economic and environmental woes require more, not less, regulation, whether state, federal, or international, and that will mean that there is always a market for trial lawyers. How much fun you have in filling that demand will depend on how wisely you frame your agreements with your spouse, your law partners, your clients, and opposing counsel. Thank you.